welcome. Thank you everybody for coming to this little Zoom session. Oh, there's Connie of estate planning. And I told Tiffany that I wanted to take just a minute at the beginning to kind of explain why we're doing this today. I guess about 3 years ago, I started losing sleep at night, wondering about our plans and what would happen if this happened, or what would happen if that happened. And certainly now having a kid kind of made that feeling a lot worse. And so just starting to poke around and do some research, I came across this book on Amazon, and I'll try to get it to focus there if I can, but it's called Get It Together. And I think it's like 25 bucks on Amazon. And it's definitely not a replacement for professional legal advice or accounting advice. But the subtitle is Organize Your Records So Your Family Won't Have to. And it includes a very exhaustive list of all the things that you might want to consider having in an estate plan, from writing a letter to your loved ones to keeping track of usernames and passwords, information about your accounts and retirement accounts, and definitely some information about wills and when you need one, and trust if you need one, and how it's better to hold the property, the title of any property that you own. And so as we started working through this book and putting our own plan together for our family, there were definitely places where we knew we needed some more professional legal help. And so that's when I reached out to Tiffany, and she was able to guide me. And now I lose sleep at night for other reasons, but not for not having our estate plan in order. Not for that same reason anymore. So anyway, talking with Tiffany a while back, I said, I want to share this information with our clients, with our friends, with our family, with the people that support the POLK team, and see if there's any way that we can help them. And so she graciously agreed. She's been our friend and attorney since 2009. We've done a lot of real estate closings with her, and we have babies that are close to the same age. Funny story is she's one of the first people I told that when I found out I was expecting, because I had told her that we wanted to have a baby, and she was praying for that and encouraging me in that. So that's how close we are. Appreciate her friendship, and also I value her legal advice. And so anyway, I'm really grateful to you, Tiffany, for giving us your time today. And so I'm just going to turn it over to you and let you do your presentation and answer questions. And then I'll pop back in at the end to say bye.
Okay. Can you guys all hear me okay?
Yes.
Okay.
In one,
okay.
Yes.
Well, as Dawn said, I'm Tiffany McWhorter. I'm an attorney at O'Kelley Sorohan, and we do primarily real estate transactions. So I'm not a probate attorney. I'm not an estate planner. But what I hope I can add some value to you, for you today is that we see transactions every week that are dealing with property that is owned by someone who's passed, or owned by someone, a trustee or a guardian. And so it's really just things that we see on the real estate end, and hopefully a little bit more, just friendly advice as far as what to be on the lookout for. Like the book Dawn mentioned, when we did our estate planning, our planner gave us something very similar. That's, log all of your passwords, make sure your family knows where these things are. One of the biggest advice pieces they gave us is to not put your wills in a safety deposit box, because nobody can get into them. So just make sure your will is, hopefully in a little fireproof box or something at the house. Everybody knows where it is. But anyway, we're going to talk a little bit about property, and I'm going to look at my notes just a little, but kind of a starting point for what you should be looking for in your estate planning. Do you need a will? Do you need a trust? What those different options are. A lot of people come to me and say, this house is the only thing I own. Do I even need a will? And the answer may be no. If you own your property as joint tenants with rights of survivorship, then whoever is the surviving spouse, title is automatically vested in that person upon their passing. So I just want to I'm going to share my screen with you for a minute to show you what I'm talking about. And if anybody has any questions on this, this is something that we subscribe to this service that I can log into and look up this stuff, with my eyes closed. So if you want a copy of your deed or you want to see how your title is vested, just email me. Dawn's got all my contact information, and I can certainly pull that deed for you. So I always search my husband's name because my name comes up with way too much stuff from every affidavit I've ever signed. So this is just how I can look and see how we hold title. And the key language you're looking for, I'm going to actually show you my deed, is right here where it says as joint tenants with rights of survivorship. So if anything happens to me, my husband Jason automatically gets our whole house. Doesn't need to go through probate, doesn't need to go through anything. All he needs is a copy of the death certificate, and that house is his. Same thing if anything happens to him, the title is all mine. So this is the easiest way to avoid probate with your property if that's your number one asset. The alternate with that is to hold title as tenants in common. So if that language wasn't there with as joint tenants with rights of survivorship, and something happened to me, then my half of the property would go to my estate and Jason would retain his. And a lot of people choose to do that, especially in second marriages where they have children that are not of the same marriage. And so, if this was a second marriage and our kids were not by the same parents, then I would maybe want my portion to go to my estate and his portion to go to his estate. But in our case, our children are both minors and they're both ours. So, I want him to get everything. He wants me to get everything just to avoid probate that really quick way. But again, if y'all want me to pull your deeds, let me know. It takes obviously 10 seconds for me and you save you a trip to the courthouse or having to subscribe to this service. Although I think Dawn and Brian have it too, because I know Brian's on there all the time. But anyway, that's what you're looking for as far as title. So if you own title by yourself, so you don't have anybody else on there with you, or if you're in tenants in common, then you definitely want to make sure to have a will. Because if not, and you die, in Georgia, it's called per stirpes. That's who gets your property if you die without a will. And it's generally speaking, a third to surviving spouse and then the rest split between children. But that can get a lot more complicated if you are not don't have a traditional family. There's lots of circumstances that can change that. I'm trying to get back to here and not share my screen. Not that you want to see me, but hang on. Are y'all still seeing me or my screen?
Your screen.
I see both the way I have mine set up. I see you and I see your screen, but that could be because I've chosen that on my end.
There we go. I figured it out. Okay. So you own property and you don't have anybody else on title with you, or you own it as tenants in common. So that's probably the biggest asset most people have. So you definitely want a will if you own property that, is not going to be automatically transferred to someone else. And a lot of people ask, do I need to pay someone $1,500 to do an elaborate estate planning package? Can I go to LegalZoom.com and, do a little 3-page will that's super basic? In Georgia, the only requirements are that your will be in writing and it be executed properly, which is signed by you and 2 witnesses and a notary. So I've seen people use the LegalZoom ones if they only have one little thing that they wanted to, make sure got to the right place. Or I can give you some good contacts for estate planners that'll go into much more in-depth estate planning, especially if you need tax planning. What most estate planning packages will include is a will, a trust if you have any minor children or anyone who needs a guardianship or, special needs care for adults, a durable power of attorney, and a healthcare directive. The durable power of attorney is an invaluable document, but a lot of people sign it and don't realize how much power they're actually giving someone. So in there, it goes through, it's a standardized form. It goes through, they have ability to go to your bank. They can sell property, they can acquire property. It's really like a very broad sweeping power of attorney. And because of that, a lot of title insurance companies, well, all title insurance companies won't let you use that to sell property unless the person is incapable of signing a power of attorney. So a lot of times in real estate transactions, we'll get somebody send us a durable power of attorney, and or even just show up to sign for their mom or dad with a durable power of attorney and not even tell us, and we can't use those. Title insurance companies want a specific power of attorney that says, for this transaction with this buyer and this seller, for this property, we are authorized this person to sign. And that's because fraud is one of the power of attorney fraud is the #2 title insurance claim. So people just don't realize, 10 years ago when mom signed her will, that she was giving me the power to sell her house 10 years later. A lot of things could have changed in that time. They will let us use them if the person is no longer capable of signing a new power of attorney. And so we just have to get a doctor's note from a treating physician that says, they're incapacitated or, for some reason they can't sign a new power of attorney. So we can use them sometimes, but we definitely, the more of a heads up, the better on those. The healthcare directive is a great form. Years ago, Georgia moved from recommending everybody have a living will and a healthcare power of attorney, and they combined it into one form that's now called an advanced directive of healthcare. And it really does both. So it goes through and you choose all of your options for your personal care. And then you also name someone in the event that there's decisions that need to be made other than the ones that are addressed in there, who you want that to be. And I'm going to share this again, because this is like I said, this is a statutory form now. So it doesn't matter if you pay an attorney to do this for you, if you go online and download the form yourself and do it, it's all going to be the exact same. And so if you just Google it, it's like on this aging website that I always go to this one because it's got really good directions. But this one, it will go through what the healthcare power of attorney, the healthcare directive is. And this is like if you're having surgery and you don't have one of these on file, most surgeons require, you to have one on file before treating. So this is the same thing that they would give you in the hospital. So it goes through all the instructions on how to fill it out properly. It's really very easy. Definitions, but I want to show you in the form how important it is. Sorry, we're not even to the form yet. This is just telling you all about it. Okay, so you can just fill this out in 10 minutes. It's no big deal. But it's very important that if you do have a medical directive, that you go through and initial all the places that are applicable. So like on here, do you want my healthcare agent to have the power to do an autopsy if they want to? Do you want your organs or body donated? How do you want your body disposed of? Do you want to be cremated? Do you want to be buried? Who gets to make that decision? And then it goes through treatment preferences, and you initial all the parts that are applicable to you. So if I have a terminal condition, which means I'm incurable, do you want life-saving treatment or not? So you really just gives you the chance to make all these decisions, allow my natural death to occur. I don't want medications, machines, or other procedures. Obviously at 41, I'm like, bring in the army, save me, because I got 2 kids to take care of. But my mom would feel totally different, about some of the procedures. So, this is something that you want to revisit every now and again. If you've had one that's a decade old and maybe some of your ideas have changed, but you definitely want to have one of these. And you want to know the person who you've named as your medical directive, you want them to know where it is. Because these can be, it sounds awful, but life or death, and making, those kind of decisions. I know you've all heard about the crazy stories where a spouse and parents will be fighting over an adult child that's in a coma or something, you know, and they're all arguing over who wins and who gets to decide what happens. So it's not just for the aging or elderly or sick. Accidents can happen, you know, on your way home from work, and you never know when you're going to need it. So I always recommend everybody have one. They're free. I mean, it takes 10 minutes. And of course, if you have any questions, just let us know and we can help you there. So I'm going to go back to here. Next thing I want to talk about was really what you want to address in your will. So the most major thing with people with minor children are who's going to care for your children and how are they going to be provided for. Most wills of people like with minor children are going to include what's called a testamentary trust. So it's not a trust that we set up right now. It's just if something happens to me and my child has not reached the age of 25, and you can pick whatever age it is, we chose 25, that a trust would be created upon our death to care for them. So it's not one that we have to deal with, you know, all day, every day. With Dawn and Brian, it was a little different because they owned multiple properties. So they were advised to go ahead and get a trust, so that, you know, it really depends on your personal situation and your goals. But that testamentary trust, you get to name two different people. So you can name a guardian for your children and a trustee for their money. And that doesn't have to be the same person. In most situations, I would say our person advised us, if you're trusting someone to take care of your kids, then you should also trust them to take care of your money. Because it's really, imagine if somebody left me their kids to care for, but didn't leave me access to the money. Like, that would be kind of insulting that, you know, but some people want more checks and balances. So some people want, you know, my sister to get the kids, but my brother to manage the money, whatever it is. But those are just things to think about. You know, do you want to, you know, do you want the person who has your kids to have the access to the money? And when I say kids, I also mean any family members with special needs. So a lot of special needs trusts are set up also for adults who have children who they still care for, you know, even though they're not minors anymore. Things to consider. So tangible possessions. I know it sounds silly, but if you have multiple children or multiple people or multiple marriages, you really want to address things like jewelry, furnishings. You know, my mom's engagement ring would be really important to me, but it's not important to my sister because we have different dads. You know what I mean? So, but my sister will want her piece of everything. So, you know, it's just little things like that to consider. Any cars registered in your name, that would include like boat trailers, boats, mobile homes. You know, don't forget about those type things. Real estate titled in your name, we talked about that. Bank accounts registered in your name with no payable on death designations. My advice is on every single account that you have a payable upon death. The person who you name as payable upon death doesn't even have to know about it. So like my brother-in-law is on our accounts if something happens to me and my husband, because they're getting our kids if something happens to both of us. And that just takes the money out of probate. So it just goes directly to them without having to go to the courts. Same thing with stocks and bonds, investment accounts held in your name with no transfer on death designation. My recommendation is to always have the payable upon death, but if not, but like our investment account, the payable upon death is the testamentary trust. So you can say, I want my 401k and my Fidelity account or whatever to go to the testamentary trust for my kids. So you really have a lot of leeway there. So non-probate property, just to give you an idea, life insurance goes outside of probate. 401ks or IRAs, they all require you to set up some sort of payable upon death. Most pension and retirements, most of those are all, you've already addressed that. So you don't have to go through probate to get access to that money. property owned by you and someone else. We talked about that. And then any brokerage accounts with payable upon death. So those are just items to think about, ones that do go through your probate and ones that don't. So as you can imagine from that, if somebody, like I always use my mom as an example, who's a single woman, literally the only thing that's in her name is her house. So people ask all the time, well, should I go ahead and add my child to title? Should I transfer title into my name? You know, if mom's going to be giving me our house anyway. And the answer differs for everybody and why you're asking that and what your situation is. But to give you an idea of the tax implications, if my mom transferred title to me today, or put me on title to her property so that if anything happens to her, that I would get it automatically, and then lived another 20 years, which I hope she does, then my basis in that property is going to be the value as of today. So when I sell it in 20 years, it's possibly going to be worth $200,000 more, you know, hopefully more than that. And so I would owe capital gains on all of that because my basis in the property is when I took title to it. Where if we wait until she passes, hopefully 20 years from now, and then title transfers then you get what's called stepped up basis. So the value that we have to pay taxes on is the value at the time of her passing, not right now when she added me to title. So that's why we choose not to, because we expect her to live a long, wonderful life. And that property she's right over by Chateau Lawn in Brazelton, and, you know, hopefully it'll be her house until forever. But that's just one thing to consider. The opposite, if you know you have an aging parent or spouse who's going to need assistance through like in treatment, Medicare, Medicaid, stuff like that, there's a 5-year look back. So even if she transferred title to me today and then needed to go into a nursing home with state assistance in 2 years, then they would use that 5-year look back. Now we are not worried about that because we've made other plans for her financially. So I wouldn't, you know, I'm not going to need the state's help in putting her in a home. But because my little brother is probably going to live with her till the day he dies. So he can take care of her. But that's just one thing to consider. They do have a 5-year look back. So they look at all your assets up in, you know, in that period to see if you're eligible for, you know, any type of assisted living, reimbursement type stuff like that. If you do go into assisted living and the state is helping, then they can put a lien on the property to recoup some of the money. So just, you know, be aware of that. But normally people who need that assistance don't have hundreds of thousands of dollars in their home sitting there unused. So that's just one of the things that you really have to talk to your professional about, because for everybody's situation, it's totally different. I also didn't want to be on any title to any more property because I have a very litigious work environment. So if I got sued, I wouldn't want my mom's house to be part of my assets, which is, you know, in my career, I'm sure I'll get sued once. It's just, that's the nature of the beast. So if you have a, you know, a really litigious type career, I don't even want to be on title to my own house. But I am. So we talked about it just briefly about persterpes, but if you do pass and you don't have a will and your family runs into a situation where they have to probate for you, persterpes is just the state law of who gets what. And I'm going to share this website with you that is wonderful. It's the Georgia Probate Court website. And like, if you just Google standard forms in Georgia, if doesn't matter if you use an attorney, if you probate on your own, which, you know, I've done both. Everyone in my family names me as their executor. But these standard forms have fantastic directions on how to file. So letters of administration are what you get if you don't have a will. Letters, executors are what you do get if you have a will. Petition for years support is something that's available only to surviving spouses and minor children. And this is a much faster probate. So this says, like, if something happened to my husband, I would file a petition for years support and say, he passed away, both of our children are minors, I get everything per this will, and it's like a very streamlined, you only have 12 months to do it. And again, you can't have adult children, you can only have minor children or surviving spouse. And the year that that's granted, you don't have to pay property taxes, which I don't know why that ever was a thing, but you know, save you $5,000 or $6,000. That's always a nice surprise for people. But in here, like if you open up the general instructions, the Georgia probate courts have spent so much time and money making these as user-friendly as possible. But if you want to read through it, I mean, it gives you such detailed instructions on how to file them, where you file. And like I said, I've done some really easy probates, and I've done some really hard ones. So, you know, just depending on the situation is whether I'd recommend that or not. But if you ever just want to look through, this is like if you ever need an emergency guardian, or, you know, they have the petition to sell property if you're in a conservatorship or something like that. So it gets a lot more detailed the longer you get down here into them. But these are all public, they're available to anybody, and they're very easy and user-friendly. And all of them, when you open them up, they all come with instructions on how to fill them out properly. So it's really, really nice. What's next here? Okay, so what are the requirements that they're looking for? So for a will in Georgia, you have to be at least 14, which I think is crazy. But I guess maybe there's some 14-year-olds a lot more responsible than my nephew. It must be in writing. Georgia doesn't recognize what's called holographic wills, which are handwritten wills. So you can't just sit there at the dinner table and write, I want Tiffany to get my house and sign it, and that be taken by the courts. It has to be signed by the testator and then 2 witnesses and a notary. And the language that's used on those interrogatories is very specific. And there's actually, if it's not included on the first will, then you have to go back, find the witnesses and have them sign one, which I've had to do before. And that's what on that standard forms file was the interrogatories to a witness. It's, you know, was the person capable of making the statement they did that day? Do you think that they read their will and understood it? And we actually have a whole checklist of things that we go through prior to having somebody sign their will, just to make sure that we've asked all the questions. And that's it. And you just want to make sure that whoever witnesses it, you actually put their good contact information, because if it ever ends up in front of a judge or somebody contesting it, then they do go find those witnesses. So you don't want it to be just a random person that you can never find again. Again, I mentioned it earlier, but don't put in the safety deposit box at a bank. Make sure that you have your will and all of your passwords somewhere safe in your home, then somebody knows where it is. That has been the biggest nightmare with people who have passed, trying to figure out where they had accounts, what their account numbers were, who the payable upon deaths is. So that book that Dawn mentioned, I think would be great for organizing that. And of course, you don't want that just sitting around for anybody to take and, you know, have all your info. But I love those little fireproof box. We have one in our closet that's got all that kind of stuff in it. And that's really it as far as the organized things that I had to talk about. One other thing I wanted to mention, if you have a will from another state, so say you move to Georgia, it's probably okay, but some states only require 1 witness and not 2. So it's always a good idea to have a Georgia attorney check your will and make sure that it would be enforceable in Georgia. And you can always edit wills. So it's called a codicil. So if you just want to change one little thing, you don't have to go through and recreate the entire will. So you can just, I said wheel, but will also. So you can do, you know, a codicil to it just to change one little thing. But if you have wills from other states and want me to just look at it real quick and see if it would fly in Georgia, I'm happy to do that. Also know that divorce and a future birth of children or adoption can render old wills invalid. So most divorce settlements state that any will that's in effect is now null and void. And that's because they don't want somebody to get a divorce and then the ex-spouse passed away 2 months later and the ex get all their money. That's probably not the intent. Same thing with adoption and future children. So like my will says it anticipates future children and it will not be revoked if Jason and I happen to have any more kids. But some wills specifically state that this does not anticipate future children, that would invalidate the will. So, depending on where you are in your life and your, season of parenting, it probably says different things in there. That's really it. Those are the things that we see the most. And again, we're here if you have any questions or if there's anything we can do. I refer all of my estate planning to Bridget Christian. She is fabulous. I've known her for years, and I've never had anybody complain. And if you have more complicated issues like conservatorships, guardianships for adult children or special needs children, Dodie Sachs is wonderful with that, but she's more family law than estate planning. You know what I mean? So those are the two that I refer the most to, but we can get you that contact info if you want it. All right. Well, thank you all for having me. Spending a little
Thank you very much.
You're welcome. I'll shoot you an email over with just the websites that I went over and Bridget's contact information, Dodie's contact information.
Okay.
And again, if y'all just need quick help, you want me to pull your deeds, you want me to look at anything, that you already have in effect, I'm happy to do that. But I do generally refer out for new wills and trust, just because it's better to work with someone who does that all day.
No. Awesome.
All right.
Thanks for coming, everybody.
Thank you.